If the United States Supreme Court has made a mistake in interpreting the Constitution, or if it thinks a previous decision of its is wrong, what should it do? Hi, my name is David Schultz, and my book, Constitutional Precedent in U.S. Supreme Court Reasoning, examines this very issue. Let me tell you about myself. I am a political scientist and a law professor. I have a PhD in political science, a master's degree, as well as a JD in law. I am interested in how law and politics connect. I'm interested in understanding how the Supreme Court decides cases, what factors influence decision making, and I'm also interested in the question of how the court approaches past decisions of its that it thinks are wrong. Let me tell you a little bit about my book. The United States is a common law country. What does that mean? For it to be a common law country means that decisions by judges and by courts carry the force of law. These decisions, especially if made by the U.S. Supreme Court, are what we call legal precedents. In common law countries, if two cases are similar in their factual patterns, they should be decided the same way. If the U.S. Supreme Court has decided a case based upon a particular set of facts, it serves as a precedent for future cases of its own and for the lower courts with similar fact patterns. The reason why precedent is important is that in part it appeals to our sense of justice, a sense, at least in the West, that two things that are similar, two things that are factually similar, should be decided in the same way. But in addition, precedent is important because it appeals to a sense of efficiency. Why should judges do things over and over again if somebody else has already decided the issue? It appeals to a sense of consistency, to a sense of uniformity, to predictability. Precedent helps to ensure that there is this sense of almost logical, if not factual consistency and regularity across the judicial system. And over time, over 235 years, the role of precedent is important for guiding the court and the lower courts in terms of how they should decide cases. Think of it then that the body of what we call constitutional law in the United States equals what? The text of the Constitution plus the Bill of Rights plus Supreme Court opinions equal constitutional law. However, what my book is interested in is not just explaining why precedent is important, but I'm even more interested in another question of how and under what circumstances can the court change its mind and reach a different conclusion about what the law means. Think about a famous example. In 1896, the U.S. Supreme Court decided Plessy versus Ferguson. It ruled that separate but equal when it comes to race was okay. Phrased another way, that racial segregation was permitted. For nearly 60 years, the U.S. Supreme Court and the constitutional law of the land was that racial segregation was okay. But then in 1954, in Brown versus the Board of Education, the court reached the conclusion that segregation was wrong, that separate but equal was not permitted, and overturned it. Over time, there have been other cases where the Supreme Court has looked back to the past and said that a decision that we had made 10, 20, 30, 50, 150 years ago was wrong, and it's time to overrule it. What my book does first is identify all the cases in American constitutional law history where the Supreme Court has reversed constitutional precedent. It then provides excerpts and analysis of cases throughout American history, going from the very beginning all the way up to the present. And what I'm interested in seeing is are there some courts, such as maybe the Warren Court or the Rehnquist Court, or perhaps the current court under Justice Roberts, are there some courts more likely to reverse precedent than others? Have the reasons for overturning precedent changed over time? And are there any trends that we can see? My book is the first major book, perhaps in decades, that does this very task. Why is this book timely? A couple of reasons. First, there's a lot of concern that the U.S. Supreme Court under Justice Roberts, with a conservative majority, is overturning previous liberal precedents by the Warren Court or others. And so there's a sense in which I examine what do we know, but also, as this video is being constructed, many are wondering, will this U.S. Supreme Court this year in 2022 overturn Roe versus Wade? Roe versus Wade is the landmark 1973 Supreme Court decision that declared that women have a constitutional right to terminate their pregnancies. There's a lot of speculation that this precedent is up for grabs and the current Supreme Court will overturn it. And thus, this book is timely and important because it examines this issue. It looks at the grounds under which precedents, including precedents about, let us say, abortion rights, reproductive rights, could very well be overturned, or when does the court opt not to overturn them. Who's this book for? It's for students and professors interested in how precedent fits into legal reasoning. It's important for understanding constitutional law, and it's also good book for political scientists, for other academics who are interested in judicial decision making and the factors that influence Supreme Court decisions. Thus, I encourage you to buy this book. By doing it and by reading it, you'll have a better comprehension of legal reasoning and the role of precedent in Supreme Court decision making. You'll get to see how the Supreme Court over time has approached the issue of precedent. And overall, you will learn a lot more about the courts, the law, precedent, and American politics. Thank you very much, and I really hope you do consider buying this book. Thank you.